Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. This is a Jay Z, Tony Buzbee, Alex Spiro update. So, this is in regards to the Jane Doe case because we know that there's like a gazillion cases that they're going back and forth on. But this is in regards to the Jane Doe case where Buzbee amended the complaint to add Sean Carter, aka Jay Z, too. And since then, they have been trying to get this First Amendment complaint dismissed on several factors. Spiro has said that Tony Buzbee has not properly vetted the client, aka Jane Doe. He hasn't filed for his admission in the Southern District of New York, and that he has violated da 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 da. Okay, this has been a back and forth since this complaint has been amended. Um, they, I don't even know what it's like, a legal battle, and it is outrageous. If y'all didn't catch my last two lives, then y'all definitely need to get up to speed with that because once again, I'm still baffled that the John Doe demand letter is not being talked about. Everybody's on Jane Doe, Jane Doe, Jane Doe and her story, when in fact there was a John Doe, and that's all we know. If you didn't know about that, check out my previous videos on that in the playlist. But going into the new filings that has been submitted starting yesterday. So the judge has finally said, look here, Tony, look here. You have stated in numerous amount of pleadings that you have either started the process for your admission or you claim that you admitted in the Eastern District or whatever the case may be. So she putting her foot down, and she said this. She's not playing with this man. She said, by letter dated December 20th, 2024, plaintiff's counsel, Anthony Buzbee, represented that he is admitted to practice in the Eastern District of New York and intended to apply for a reciprocal admission to the Southern District. In his declaration dated January 22nd, 2025, Buzbee stated that his application for a reciprocal admission is forthcoming. Accordingly, by February 14th, 2025, Buzbee shall file proof of admission on the docket so ordered. If I have to drive to Houston and fill out the paperwork and get him to sign it so we can get this wrapped up, call me. Because, man, like, that's this is probably the only thing that I'm not understanding as to why this man has not filed his admission yet. All right. Now, going into this, so Jay-Z's attorney, on behalf of Jay-Z, has submitted their, how can I say this? This is a memo to further support their motion to sanction Tony Buzbee and to dismiss the complaint again. Well, to dismiss the First Amendment complaint that named Sean Carter as a defendant. Y'all, we can't make this up. I think we all tied. We all tied. So look what this memo states. Preliminary statement. A principal attorney, when confronted with factual inconsistencies that cast grave doubt on horrific allegations and reveal the inadequacy of the pre-filing inquiry, would can reconsider the lawsuit. Instead, plaintiff's lead attorney, Tony Buzbee, tried to gloss over them. Initially, he deflected, saying plaintiff's case was referred to his firm by another who vetted it prior to sending it to him, and that his firm would continue to vet her claims and collect corroborating data. And he's once again referencing what NBC said, and this is what Tony Buzbee talked about in the last pleading. Like, it, the four corners, the four walls, anything outside of the First Amendment complaint not need to be referenced. So why are you referencing what somebody said on a interview? But continue. Now he concedes that he did not even meet with plaintiff before signing his name to the complaint and fails to identify any evidence that corroborates anything his clients alleged. Meanwhile, he has litigated this matter for 3 months without seeking admission to the court or explaining this failure, including throughout earlier cases he filed in this court. Um, I'm wondering if Spiro had the opportunity to read the last pleading that Buzbee submitted. And the reason why I'm saying that is because Buzbee told us how the client was vetted. The retired police officer, 2 to 3 attorneys, team attorneys, solo attorneys, like, okay. Mr. Busby studied detachment from the mandatory diligence and admissions procedures contrast starkly with his exertions outside of the court. This is no denying that he has, in press conferences, social media, and media interviews, systematically weaponized the allegations of his still anonymous plaintiff due to damage Mr. Carter's reputation. Mr. Busby is conducting himself as he knowingly that his in court submission may be cloaked in immunity. Mr. Carter seeks only to hold Mr. Busby to the ethical standards that constrain any responsible attorney who would solemnly sign his name to allegations in court. Without such guardrails on litigation, there is obvious risk. Someone in Mr. Busby's position could level reputation destroying allegations indiscriminately in court with an eye towards leveraging them in sensationalist fashion outside of court without ever properly inquiring into the truth or facing accountability. That concern looms large here. Mr. Carter has identified factual inconsistencies demonstrating that allegations in the First Amendment complaint were false and highly suspect. Those inconsistencies undermine nearly every step in plaintiff's narrative: her arrival and whereabouts of the VMAs, her interaction with celebrities and purported residents, the timeline, and how she got home. Plaintiff's opposition does not meaningfully, engage these demonstrated inconsistencies. Notably, for the one issue she seeks to rebuke, whether Mr. Combs owned a home fitting the First Amendment complaint's description, plaintiff's arguments only confirms the errors. All told, plaintiff lacks any satisfying answer to identified discrepancies. It is now common ground that neither Mr. Busby nor any of his colleagues ever so much as asked the plaintiff's father whether he remembered playing his critical multi-hour role in the remarkable tale spun by the First Amendment complaint. If they had, they would have learned what a curious NBC News reporter learned by posing that simple, easy question. He remembered no such event. There we go, once again, referencing an NBC interview and not the contents of the First Amendment complaint. Mr. Busby now suggests myriad ways that our rigorous investigation was performed by unnamed colleagues. You don't have to name them, but those efforts failed to satisfy his own Rule 11 obligation to conduct a reasonable inquiry pre-filing into allegations that facially test the outer limits of the credulity and indeed fly in the face of readily ascertain facts. Mr. Busby could not farm out to unspecified others his Rule 11 obligations, which attach personally to him as the signer. They are non delegable, and having purportedly left the requisite vetting to others, Mr. Busby cannot now properly serve as one lone declarant, attesting to matters that are outside his personal knowledge and known only to non-declarants who sit silent. You know what's crazy is because I laugh at this, and the fact that Spiro is saying this is wild. I don't even know if I should say this, but technically, technically, when we get clients, either the case manager or the paralegal, like myself, usually do the intake. Um, I've Never ever seen and I'm talking about in whatever type of case, SA case, car wreck case, wrongful death case, you name it, right? So when we do the intake, usually the attorney will meet with the plaintiff, like if they're prepping them for depositions or they're prepping them for a mediation or they're prepping them for trial. I'm just gonna put that out there. I'm gonna be honest with you. Now, will there be other attorneys? It just depends on the situation. Yes, clients love to hear from their attorneys, but attorneys handle so many cases. That's why they have paralegals. That's why they have associate attorneys. So just by you saying that because he personally did not, you know, interview her, somebody in the firm did. The people that, whether it's experts or whatever the case may be, they did. Attorney, he just, of course, a paralegal probably drafted this and added his signature there and filed it. Not so, and I'm pretty sure he probably reviewed it or an attorney reviewed it. The managing attorney usually signs this, and that's why you see Buzbee's name on it. So anybody who works in the legal field, hey, don't come for me because I done spilled the beans, okay? But just know this is not a reason to have the First Amendment complaint because he personally did not vet her. There's a system that law firms have. Now, if it was a smaller firm where it's a solo practitioner and they don't have a paralegal, then yeah, or any other associate attorneys, yeah, I see that. Then they have no choice but to do that. But when you have a trial firm, such as the Buzbee firm, you have associate attorneys, you have paralegals, you have legal assistants, you have legal secretaries, you got a receptionist, you got a HR department. All right. Even assuming Mr. Busby had a reasonable basis initially to file the claim, post filing exposure of substantial inaccuracy should have led him to withdraw it. He cannot continue post complaint to whistle past demonstrated inaccuracies in plaintiff's allegations that are staring him in the face. Rule 11 sanctions are well warranted, and Mr. Busby's attempt to demand sanctions of his own is meritless. So once again, their argument is that the court should impose sanctions because he failed to investigate adequately before he filed the complaint, and he failed to actually, excuse me, he failed to admit to the Southern District of New York. And they're just kind of calling out all of this. Look, as to Busby's reliance on other lawyers and a retired police detective to interview plaintiff and fact checked her account, none of those individuals has even been named, let alone produced as a declarant. Um, I don't think that is necessary. And then look, they fact checked allegation. Friend drove plaintiff to NYC. When asked this person's identity, counsel identified a then 20-year-old, now deceased. Once again, according to the NBC article, that's outside of the First Amendment complaint. Plaintiff watched VMAs on Jumbotron. False. Limousine driver offered ride to after party. False. Party at a large white residence with U-shaped driveway 20 minutes from Radio City. False. Plaintiff signed what she now believes was an NDA. Not fact checked. Plaintiff lacks any such document. Nobody took their NDAs home. Nobody. No, they didn't say, hold on, let me make you a copy and you keep this on you at all times. Plaintiff spoke with celebrities at party. False and or highly suspect. Plaintiff purportedly rugged, found a room to lie down. Cannot fact check, but they say plaintiff told no one for 24 years, did not undergo a toxicology screening. Once again, they're quoting from the NBC article. Plaintiff ran out the house to the closest gas station. Cannot fact check. Plaintiff told no one for 24 years. Now claims to not know the resident's location, let alone gas station. Once again, they're quoting the NBC article. And the father picked plaintiff up just before dawn. False. He states that the only research Buzbee firm apparently conducted was to confirm the close connection between Carter and Combs. Oh my gosh. And he's just repeating what he said. First, in responding to Mr. Carter's argument that public property records prove that Mr. Combs did not own a residence that fits the First Amendment complaint's description in 2000. Plaintiff wrongfully accuses Mr. Carter of misstating facts. Zeroing in on the 40 Hedges Drive residence, plaintiff argues repeatedly that Mr. Carter represented that Combs did not own this property until 2001, revealing his lawyer's own mistake concerning details on which they rely. Far from disputing that Mr. Combs owned that residence in 2000, the motion notes that he did. And he did. What? Mr. Carter's point and remains that neither this residence nor any other owned by Mr. Combs matches the description. I'm confused because hold on, let me look read. To reiterate, while the specified residence is a large and white, it does not have a U-shaped driveway that is located in the East Hampton, a minimum 2-hour drive and over 100 miles from Manhattan. If y'all, oh my gosh, I need to pull that up because it does have a U-shaped driveway. And anybody, it doesn't have to be a big U-shaped driveway. It just has to be a U-shape. You go in one end and you go out the other. That is considered a U. I pulled that up. I literally pulled that up. Rather than address these demonstrated disconnects, the opposition whistles past them while misleading the motion to manufacture a supposed gotcha. That is false. That house does have a U-shaped driveway. I need you to go back and do your research, Spiro, whatever your name is. Second, Mr. Busby dismisses plaintiff's father's denial of picking her up that night, claiming the events occurred 24 years ago. All right, we're talking about the 10-hour pickup. Plaintiff dismisses her imagined conversation with Benji Madden as irrelevant simply because it was not discussed in the First Amendment complaint. But the point is that the plaintiff allegedly spoke with the celebrities at the party. And that's what they never put a name on it. So in the First Amendment complaint, it stated that she allegedly spoke with celebrities at the party. It did not put a name on it. They're just referring to the NBC article. The NBC article in which Tony Buzbee should not have allowed her to go on NBC. That's number one. But number two, it just all depends because sometimes clients won't tell you if they have been contacted by any news media. But normally, when they sign up, I'll be like, social media, refrain from posting on social media, refrain from talking to the news outlets, all this other stuff. That should have been told to her. So that way she would have known. But in no way, shape, form, or fashion should she have even done an interview because look where we are at right now. That was probably the worst thing she could have done. Um, Where he says plaintiff dismisses photographs showing Mr. Carter at Lotus on the night in question, theorizing he could have party at the residence after the nightclub. That's what I said. But it says, but that makes the timeline even more far-fetched, as Mr. Combs and Miss Lopez attended two nightclubs, Lotus and Twirl. Okay. The First Amendment complaint requires the plaintiff arrived at the gas station after the alleged assault around 1:30 a.m., 5 hours before dawn, after fleeing the alleged party. Given that the VMAs ended at 11:11, in approximately 2 hours, Mr. Combs would have had to been driven to two different nightclubs, each at least 14 minutes from Radio City with zero traffic and 6 to 14 minutes from each side. Spent time at each club where he was photographed. Been driven to the imaginary residence at least 20 minutes from Radio City. While his driver returned to Radio City to pick up plaintiff. At least a 40 minutes wait. Waited more time while plaintiff mingled with celebrities and got intoxicated and then assaulted plaintiff. Assuming arguendo that timeline could somehow be wrestled with the laws of physics, it cried out for reality testing. This is interesting. I mean, it is interesting, but then we have to look at all the facts. We gotta look at all the the facts that we have right now. In my opinion, I think Tony Buzbee put in a pleading that there's only one graph of Diddy at a party, no other photos, because if you are at a club, right, and you are at that high status, everybody's going to want a picture with you. So it's just like he went in for a couple of minutes and dipped. And that's normally if you ever been, I just recently went to when Kodak Black was down here in Dallas. That dude was probably in there for 30 minutes. 30 minutes and then he dipped. Okay? They don't stay the whole time unless they are actually performing. And they barely do that. They'll do their set, they'll get there a couple of, minutes or probably an hour, get freshened up or whatnot, go on stage, do a couple of songs. Next thing you know, they go back, do what they do, and then they dip. So that's one thing. That's one theory I'm thinking. So I don't believe it could be a possibility. Now, as far as the house, the house, as I stated, that 40 Hedge Drive, that is the only house, big white house with the U-shaped driveway. Now, it is if she was, I don't even know, because were you intoxicated while you was, when you went in the limo? Uh, I don't know. I don't know. I mean, everything is questionable. Everything is questionable. But at the end of the day, that is the whole purpose of going through the litigation. Plaintiff denies Mr. Carter's evidence that she could not possibly have watched the VMAs on the Jumbotron or spoken with the limousine drivers. But plaintiff could not have watched the Jumbotron because they're saying that they didn't have the license or the permit for them to do that. All right. And they say sanctions are warranted. Oh, and they say plaintiff is not going to get attorney fees. They was like, this man then filed this frivolous lawsuit. She should not be entitled to attorney fees because that's what he asked for in his last pleading. Oh man. All right, so here's your boy Spiro's declaration in support to their the motion for sanctions and to dismiss the complaint. So let's see what he said. He said, I've been admitted to practice in the state of New York since 2008 and until January 8, 2025, I have never filed a Rule 11 motion in any federal court or the equivalent in any state court, despite having litigated many hundreds of matters. NYPD informed us that the denial of the MTV's permit for a jumbotron was not only applicable to the immediate area outside Radio City Hall, Music Hall, but throughout New York City. Attached here too is Exhibit 1 that shows let's see, a publicity poster for the 2000 VMAs. Exhibit 2 is a screenshot of the broadcast of the 2000 VMAs. Exhibit 3 is the Google Maps showing the distance and a typical driving time on a Thursday evening in September around 11:11 p.m. from Radio City Music Hall to the Lotus nightclub. Now, the only thing I have an issue with is because that is two that is 25 years ago. 24, 25 years ago. Things have changed. And I know even out here from where I graduated high school in 2000 till now, Dallas has built. It does not look the same. So I don't think that this would be a logical um exhibit to use, only because you never know. We never know. When I looked on Google Maps from Radio City to the White House in the Hamptons, It said 2 hours and some odd, minutes. But things could have changed. Highways could have been built, more houses could have been built. It may take longer. We don't know. I haven't had the opportunity to even look to see what it looked like in the 2000s in the 2000s versus now. So, um, he also attached a Google Maps showing the distance and typical driving on a Thursday evening in September around 11:11 from Radio City to the Twirl nightclub, and then Google Maps showing from the Twirl nightclub to the Lotus nightclub, and then Exhibit 6 says a true and correct copy of the U.S. Naval Observatory's table sunrise and sunset, moonrise, moonset, and twilight times for the year 2000. And then a screenshot of Google showing the distance on a Thursday from Radio City to um 40 Hedges Bank Drive. That's the big white house. Oh, ooh, wait a minute. He discussed this. Remember Marcy Croft? Marcy Croft is with MJ Legal. That's her firm out of Mississippi who is partnered with Quinn Emanuel for their initiative to help inmates. I forgot what the thing is, but with Rock Nation and Quinn Emanuel. So he addressed this here. I gotta do an update because there is an update in regards to the Houston cases that Buzbee filed against Rock Nation, but I'll probably get to that tomorrow. But he states Mr. Busby's declaration made several allegations concerning an attorney named Marcy Croft. He further claims that Miss Croft and I have worked alongside each other for years. I have never met Marcy Croft. Several years ago, I worked with Miss Croft on one pro bono case in which I advocated for the closure of 3 Mississippi prisons for maintaining harsh conditions that violated inmates' constitutional rights. As a result of the work on this matter, on February 28, 2024, the Justice Department issued its finding that these conditions violated the 8th and 14th Amendments of the United States Constitution, leading to the closure of these facilities. I was one of 5 attorneys involved in that case and at best spoke on a conference call with many of them. I have not spoken to her since that matter. I know nothing about her purported investment in any misconduct alleged in Mr. Busby's declaration. Other than that, Mr. Busby asserts such allegations. I'm crying. He just had to throw that in there. Y'all ain't say nothing about that John Doe. The mail letter, though. Mm. Let's take a look at these exhibits right quick. That's the VMAs. Okay. Um, I don't even know what the purpose of that picture was. Okay. Okay. Alrighty. Don't know what the purpose of that is. You're just showing us the music hall. All right. So what did they say? The Lotus Club first? So I'm saying this is the Lotus Club. All right. 14, 15 minutes, 14 to 35 minutes. All right. Typically 8 to 24 minutes. So just depending on. So this is from Radio City to Twirl. Okay. Now is this from one nightclub to the other nightclub? I believe so. 6 to 12 minutes. And what y'all saying walking? Oh, let's see what we got here. 6. So in September 8th, the sun rised at 5:30. And it's set at what is that? 13 is 1. 6 yeah, 6:16. Oh, because she said that before dawn. Interesting. I don't know what the purpose of all this. And this is what I it'd be funny if they took my stuff, but they didn't. But yeah. Now I pulled it. I don't even think it said 2 hours. But regardless, it's a 2 hour drive from Radio City to the Hampton place. Oh, excuse me. Yeah. Huh. I mean, it's already out there, right? So what I'm gonna do, let me pull up 40 hedges. Hell, I ain't like at this point everybody can pull up the damn everybody can pull this address up. All right, let's get into there to the Google. Let's get in there to the Google Maps. They're still not talking about you. You talked. It's the John Doe part for me. All right, so you go in right there, and then it goes around, and you come out right there. Isn't that a U-shaped driveway? Not unless I'm just slow. Look at this. So you go in. That is a U-shaped driveway. That is considered a U-shaped driveway. Um, oops. Where the little man go? Here we go. I'm trying to even if I go back and do this, let's put on layers and let's zoom in. I mean, it's kind of contorted, but you can see it. Goes in there, comes out. So that's still a U-shaped driveway. If you go in one end and come out the other, that would be considered a U, to me, at least. So I'm not getting it. I'm not getting it. Like we said, we know that there's a lot to this case. And everybody's not going to agree with me, and I totally get it. Everybody think I'm getting paid to bash Jay-Z, and no, I'm not. Because trust me, if I was getting paid by anybody, I would be on an island somewhere minding my business, not thinking about YouTube or social media. Okay? All right. Um, but everybody's going to have their opinion when it comes to this matter. The only thing I want people to understand, once again, this is a highly sensitive matter. This is a sexual assault case. It's not going to be handled the same way as your normal civil cases. Okay. So when a client comes in and they say that they have been assaulted and they have gone through what they've gone through the vetting process, then at this time, even if they have enough evidence as far as their word goes for us to go ahead and file a lawsuit and start the process. It is during discovery as to when we will see. Well, we won't see. It's going to be done behind scenes, but they're going to have their experts there. This is not the only time. The intake part is not the only time that she is going to be questioned. Okay, she's going to be questioned during depositions. She's going to be questioned by expert witnesses that actually specializes in, if they say she is autistic, then they're going to have a specialist that come work with her to trace her memory. But we have to give her the opportunity to go through that stage. Now, people are still going to say, well, this John Doe, her Jane, the Jane Doe case don't make no sense. Da 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 da. Da. Let me tell y'all something. In that John Doe letter, Buzbee said they have evidence, substantial evidence that proves that he was there, that he did what he did. That we have yet to hear about it or see anything associated with that John Doe. So, because those two letters were sent out at the same time, Yes, I believe everything that has been alleged thus far. I'm always going to side with the plaintiffs, always, until otherwise. As a professional, as a plaintiff paralegal, I've told y'all this time and time again. I side with the plaintiffs until I do my because I am actively working these cases. So until I find otherwise, I'm siding with you. And if I find something iffy, I'm coming to you and I'm questioning you about that. Why? Because I know if I find it and I bring it to the attorney's attention, we have to know how to be prepared when it comes deposition time and their attorneys are hounding you. So everybody can feel how they want to feel. Okay. I stand with Jane Doe. I stand with John Doe. And because John Doe hasn't seen the light yet, you best believe, I believe that there is some truth to all of this. He don't want that John Doe to come out. As we talked about this in previous lives, it's easier. He thought it would be easier to dismiss this Jane Doe case because nobody would believe her. Just imagine if the roles was reversed and he filed suit against the John Doe and the evidence really came out. Then what would be y'all stance on that? Definitely comment. Don't forget to like, share, and subscribe. Until then, you all be blessed and I'm out. Bye.